All right, everybody, let's get started. Just a quick reminder for anybody who's here for CLE credit, you got to sign in and sign out for each session, so please remember to do that. We're going to now kick off this wonderful panel on Delaware's recently enacted SB 21. We've got a star-studded lineup here. Eduardo Gallardo, who's co-chair of the Mergers and Acquisitions practice at Paul Hastings, and a member of our advisory board here at the Millstein Center, and also a Columbia Law grad. Ann Lipton, who's a professor of law and the Laurence W. DeMuth Chair at Colorado Law. She's also a frequent contributor to the Business Law Prof blog, where she's written a lot about SB 21, and the co-host of the Shareholder Primacy podcast. Edward Rock is the Martin Lipton Professor of Law and co-director for the Institute for Corporate Governance and Finance at NYU Law. He's got a new article discussing the new political economy of Delaware corporate law that we hope to hear about here today. And last but not least, we have John Mark Zeberkiewicz, who's a director of Richards, Layton, and Finger in the firm's corporate advisory group. He's also a member of Delaware's Corporation Law Council and has served on drafting subcommittees responsible for significant amendments to the DGCL, including SB 21. Okay. So, take a seat, and so to start, I want to begin with Ann. Can you all hear me? Good. So Ann, just to get us all on the same page here, can you tell us a little bit about what SB 21 did, and I mean both in terms of the substance of the changes, but also in terms of whether and how they were meaningful? Depending on who you talk to, some people will say, oh, SB 21 did very little, right? It just returned Delaware law back to where it was, or where it's always been, where it always was. Other people say things like, this is the most extreme set of changes we've seen in a half century. So can you help weigh in on this? Like, where are we with SB 21?
Okay, so this is in no way a neutral accounting. I'm going to editorialize. But that's okay, because it's a pretty sophisticated audience, and I know my panelists will disagree with me. Will not be shy. So what SB 21 did was it made it much easier for corporations to cleanse conflicted transactions. So there are basically two ways to cleanse a conflicted transaction: independent directors or the disinterested shareholders. And so the first thing that the bill did, that the statute did, was reform the concept of independence. It adopted this heightened presumption of independence for directors who are designated by the board as independent for the purposes of stock exchange listing rules, and that heightened weight of rebutting it. But a lot of transactions involve controlling shareholders, so in exchange-listed companies, they identify the directors who are independent from the company, but they don't really identify the directors who are independent from the controller. So the statute has this additional language that for controller transactions, you take the standards for company independence, but you apply them as if the controller was the company, and then the director is, and determine whether the director is deemed independent of the controller. So a couple things. First, this definition is in the statute only for the purpose of cleansing conflicted transactions, but I assume it's going to be used for demand excusal. I mean, that just seems obvious to me. But second, this is a very weak independence standard when Delaware had been moving in the other direction, because the companies themselves get to identify who's independent, and the exchanges are pretty famous for not enforcing their rules. Third, the exchange standards, they ask the wrong question. Delaware used to ask if a director was independent of someone else who was interested in the transaction. But the exchange standards ask if you're independent of the company, which is just a different question. And fourth, when there's a controller, I don't understand the language, because the language is about you presume independence from the board designating someone as independent. But when it's a controller, boards don't designate people as independent from the controller unless they're doing it for the purpose of litigation. So I'm really not sure how that's going to play out. So that's independence. Next, we have these cleansing standards. When the board is majority independent and there's no controller in the mix, the deal can be cleansed either by a full board or by a committee. If the deal is majority conflicted, but there's no controller conflict, then there must be a committee. Either way, must the committee itself be majority or completely unconflicted? No. There are no standards for committee creation at all if the board is majority unconflicted. They can do whatever they want. And if the board is majority conflicted, the committee has to have 2 members, and the members have to be people that the board judges to be unconflicted. They don't have to actually be unconflicted. They just have to be judged by the majority conflicted board to be unconflicted. And after that, the deal is cleansed if a majority of the actually unconflicted directors on the committee approve it, which basically means if a majority conflicted board creates a committee of 3 people, 2 of whom turn out to be conflicted, the deal can still be cleansed if that one remaining one approves it. And that's obviously a change in the prior law where you would have had to have had at least a majority unconflicted committee. Stockholder approval. That's permissible as an alternative to board level cleansing. But those standards are weakened as well, and we see that by comparing to how director cleansing works. So director cleansing works according to the statute if, and I'm quoting, the material facts as to the director's or officer's relationship or interest and as to the act or transaction, including any involvement in the initiating, negotiation, or approval of the act or transaction are disclosed or known. But that's not the standard for stockholder approval. It was the standard for stockholder approval, but they took out all that language about the stockholders being informed about material facts of directors or offer relationship or interest in the act or transaction. All of that was taken out, and now it just says that the stockholders have to be informed, where informed is left kind of undefined. We don't know how courts are going to interpret this. I mean, it just hasn't been litigated yet, but I'm assuming that the disjunction in language, where directors have to be informed of a bunch of different things and stockholders just have to be informed, I'm assuming that disjunction in language is intentional because in the past, directors have argued that shareholders can cleanse if they know the economic facts, but without knowing any of the process. And they've lost on that in the cases that they've litigated. So I'm assuming that the language about what shareholders have to know was deliberately softened so that directors get another shot at this argument that shareholders only need to know the economic terms and they don't need to know the full negotiating history. Finally, controller conflicts. Under prior law, who was actually a controller was this sort of multi-factored fuzzy test. Under the new statute, it still can be fuzzy, but, and I know Ed disagrees with me on this, but I read the statute to say there's a hard floor. You have to have at least 1/3 of the voting power to be a controller at all, which means if you have a contractual control over various corporate transactions, like say the Moelis agreement, but you don't actually have 1/3 of the voting power, you aren't a controller. So unless you occupy some other position, your transactions aren't conflicted at all. There's no there's no cleansing because there's no fiduciary involved. And if you are like an officer or a director so that there's a conflict with a contractual control in place, then the cleansing is just going to be the same, just the ordinary way that we cleanse for a conflicted board or an unconflicted board. And then if you are a controlling shareholder, meaning that you have at least 1/3 of the voting power, it's basically the same cleansing regime as for a majority conflicted board with all the same wiggle room, unless you're engaged in a take-private deal, in which case you need both shareholder and committee cleansing. So that's basically the substance of the law, which is obviously sort of convoluted, but I still think whichever convoluted path you take, it's meant to go in one direction, which is shareholders lose. I think these standards are fairly comically undemanding. I think outside the context of outright fraud, they're going to be very easy for boards to satisfy, and I think that's kind of the purpose. I mean, this was pitched to companies as now you can have certainty. Well, the only way you can have certainty is if you essentially take courts out of the business of reviewing transactions. So that's kind of where we are.
Okay, great. I want to thank you for putting all of that out there, and I want to go into many of the things that you put on the table for us. But first, I kind of want to hear reactions from others if others want to jump in and say, you agree with Anne's top line verdict on this, that this is, taking us closer to, or, approximately to where Nevada is on law, where, it's going to be very difficult for shareholders to prevail in this, new state of affairs. John Mark, you look like
Obviously, I disagree. I don't think it's as extreme as portrayed, and I respect the views, and I think we both agree 100% on how the controlling stockholder, and Ed, I know you dissent, but you're wrong. So look, I don't think it's as extreme. I don't think, look, if you're looking at section 144A, which deals with when you have an officer or director who has a conflict of interest, but a majority of the board does not. I'm not sure that's really it's functionally not different from the business judgment rule. So if you're taking issue with that, I think you're really attacking one of the foundational principles of all of corporate law, which is that, courts are going to defer to the good faith business judgments of, directors, a majority of whom are unconflicted, right? I mean, that if we're not deferring to independent, disinterested decision makers, what are we doing? We're going to review every transaction? That seems inefficient and just, we'd be in a litigation nightmare. Look, I take the point. I think that there were different views on whether, Section 144B, which deals with, conflicted controlling stockholder transactions not involving a going private. There were legitimately held different views on whether, in order to cleanse a transaction in which a controller received a non-ratable benefit, whether those needed to be approved by both a committee of independent disinterested directors and subject to a majority of the minority vote of the disinterested stockholders. In 2016, I think in Re Easy Corp, Vice Chancellor Laster made it very clear that his view was that yes, whenever you have a controlling stockholder on both sides of a transaction, you needed to have both of those protections in place if you wanted to get back to business judgment or something akin to business judgment. I think Chancellor and ultimately Chief Justice Strachan disagreed with that very strongly. I remember I was actually at the University of Pennsylvania and I was talking about In Re Easy Corp, and I think he was jumping down my throat saying, like, I think you're wrong. And I'm like, look, all I do is read cases and report. So, I mean, I think there were different views on that topic. And look, I think, in terms of like, is this just, the easiest path? I mean, look, you still have to act without gross negligence. There's still, good faith standards. I think our courts are pretty sophisticated. There are some open questions. No piece of writing is ever going to be perfect. I think that's why we generally take a philosophy that our courts are sophisticated enough to figure things out where there might be, some gaps.
Ed, you want to jump in on this, or?
Sure. Which piece?
Your choice.
So, I guess I disagree with both of you, but on different things. So I don't think SB 21 does very much, because it's not going to be interpreted or applied by an AI bot or by a judge, an unsophisticated judge. It's going to be applied by Chancery Court judges who are expert. And there's plenty of room if they think that either the director approval is compromised by interest or dependence on either interest in the transaction or dependence on a controller, then there's plenty of room within the statute, within the statutory language, for them to disallow the cleansing. And often, if the disinterested director approval is insufficient because the directors are in the pocket of the controller or whatever, the disclosure is also going to be insufficient. So I'm not very worried about the actual effects of SB 21 in the hands of the Delaware Chancery Court. I don't think the changes are all that major as they will be applied.
So
there is a question.
Oh yeah, no, go ahead.
There is a question which both Anne and John Mark raise, which is a question not that I raised, but the statute raises. And the statute is drafted as a safe harbor statute. That's what the synopsis says. That's what all the law firm memos say. Everybody said it was going to be a safe harbor statute for controller transactions. And, I've taught securities regulation. I taught it out of Jack Coffey's book when I was visiting at Columbia and had Jack down the hall. And the securities regulation notion of safe harbor is a pretty clear one. It's that if you satisfy the requirements to get into the safe harbor, then it's not an illegal transaction. Okay? It's not an underwriting or whatever. If you don't satisfy the requirements of getting into the safe harbor, it's not that the transaction is either per se legal or per se illegal. It's subject to the background law, and it has to be analyzed under that. And if you read 144 as amended with that notion of safe harbor in your mind, it's pretty clear. If you satisfy the definition, the statutory definition of a controller, and you satisfy the required cleansing acts, then what the statute says, and it's also quite interesting because it's drafted as an exculpation statute essentially, it says there'll be no equitable relief and no monetary liability. That's what it says. And so in a blog post that Marcel Kahan and I did in the Harvard blog, we gave that reading of it. Now, what that means is if you are not in the safe harbor, either because you haven't satisfied the cleansing requirements or because you are a de facto controller who's not a statutory controller, such as a molus controller, a founder, say, who has 28% of the stock, and a comprehensive molus-style stockholder governance agreement that doesn't give the right to elect directors, but gives the right to pre-approve directors, nominees of the company. That in that circumstance, on our reading of the statute, you're subject to the pre-existing Delaware law because you haven't satisfied the requirements of the safe harbor. Now, you can make an argument, as John Mark was suggesting, as Ted Mervis argued also in the Harvard blog in response to our reading, that that's to misunderstand both the legislative history as well as the statutory language. And by legislative history here, I think what he means is what everybody was talking about, as opposed to simply the synopsis. Because Delaware doesn't really have much legislative history in the classical sense. There is the synopsis. Now, that may be right. And I'm not pretending that our reading of the statute is what people thought they were enacting. But they enacted a statute. But the more important point, the more important question, is if the other reading of the statute is the right reading, that is to say, you cannot be considered a controller for purposes of fiduciary duty analysis unless you have at least 1/3 of the voting rights. If that's the reading of the statute, you have to have an answer to the question about the 28% founder. It's not a CEO, not a director, and therefore doesn't have fiduciary duties by virtue of their status. The 28% founder who has effective control through both the shareholdings and the stockholder governance agreement, who enters into a transaction with the corporation that is an interested transaction, whether it be a going private transaction or some other interested transaction. So one answer is our answer, which is subject to the background law. Another answer is to go to the other extreme, which Ann was suggesting, which is no fiduciary analysis at all. Because if you're not a controller, you're not a director, you're not an officer, you don't have fiduciary duties. There's a third answer, and I think we're going to write up for a response to Ted's blog post also which the third answer is what I consider to be the very useful saving clause, which says that none of this affects aiding and abetting liability. So it suggests the following analysis. I'm curious whether other folks think this is plausible. If you don't like our de facto controller concept, but all the facts are the same as a going private transaction that is at the behest of the 28% shareholder with the stockholder governance agreement, you can say that that guy is an aider and abetter of an exculpated breach of fiduciary duty by the board. That framework, a framework which we're familiar with from the rural metro litigation, where you had a investment banker who misled, who defrauded the board breached its duty of care according to the court, but it was an exculpated and innocent breach of the duty of care, but the investment banker was held in as an aider and abetter of this innocent exculpated breach of the duty of care and held liable for quite a lot of money. So maybe that's the way you reach the de facto controller who falls outside of the definition of the statute.
That is actually what the drafters had in mind.
Is that what the
I will
drafters-
say that as one of the drafters. I mean, it was very clear that, you know, the statute 144D basically says, look, if you don't meet the definition of controlling stockholder or control group, you're just not, which means no fiduciary duties.
For the purpose of this.
No, that's in the definitions. In E, it says for purposes of this section. In D, which is a different section, it just says blanket, you're not. So you're not. And the synopsis was very clear, and actually that language was deliberately designed to, you know, kind of undercut this argument, but it didn't work as well as I would have hoped, I guess. So that is, but there was a very clear preservation of aiding and abetting liability. So that was the design.
Grace.
well,
Anne,
no,
why don't you jump in, then I'm
Well,
going to
I'm
ask
just
Eduardo
curious,
something.
I'm not sure I understand what the breach of duty by the board is that they are aiding.
So it's a breach of the duty of loyalty if they're doing this
Well, if they're doing it
on behest of or at the demand of the
If they're doing
controller.
it because they're beholden to the controller, okay, I see that. But if it's because they're doing it because they've already, this non-controller controller has contractual control rights, I'm not sure that they're, unless we're going to develop, which Delaware is clear of, a breach of duty, a requirement that your fiduciary duty requires you to breach a contract, which I'm not sure we're there.
Nope.
But, so, I'm just not.
So I think there's a serious question. So if you play out the hypo, which is this is a controller, a non-controller controller, who through exercise of the veto rights and the pre-approval rights has made it really difficult for the corporation to do its business. Okay? And now the board makes a good faith, informed decision that giving the controller, say, an opportunity to buy a key division at a discount price is a good way to satisfy the controller and get him to leave us alone so that we can get on with running the business. Now that's a hard case because that seems to be a business judgment.
Exactly, I don't see the
Right.
board's breach there to aid.
That's a fair point. That's one of the problems with that theory.
So I'm going to pivot for a second, then we'll come back to ask some more questions about the drafting intent. Eduardo, I just wanted to hear from you a little bit about, you know, what are you hearing from your clients about the reception to these changes? And this is another way of getting this top line question of, is this a big deal? What is it, you know, designed to do? Are clients been receptive? And I guess, you know, part of this also is, what were you hearing before SB 21 from clients about, you know, the environment in Delaware for M&A?
There was a lot of unhappiness about, and it's not only, keep in mind, this is not only about SB 21, right? We have to go back to last year and various opinions that came out before then that I think were not terribly well received by corporate clients, and frankly were not terribly well received by certainly New York corporate lawyers, right? There were decisions that, I'm sorry, I'm distancing myself a little bit of SB 21, but I'll come back to that. But there were decisions that, you know, for example, the Activision case, right? That said that sort of the way that corporate lawyers have practiced, at least the way that Tom Kennedy taught me to do M&A, was that you would come up to, you know, you would come to the meeting the final meeting with the board of directors. You would approve all the material terms of the agreement, but you would have an agreement that maybe goes around without the name of the parties, and you did that for confidentiality purposes. You know, Activision comes out and says, well, that might make the deal non-compliant with the statute, right? The fact that you didn't attach the merger agreement to the notice that goes out to shareholders, but was not next to the notice, but at the end and the back of the document, that created a statutory problem. And then you have Mueller's and other developments, and I think there's a little bit of some anxiety about the direction that Delaware was heading. And I think what you saw last year with the amendments and SB 21 is a little bit of a course correct, some people would say, about the way that things were going, and just made us all collectively feel a little better that, you know, we could provide the clarity to our clients, to our transactions in a way that we were starting to doubt whether we could give. I mean, the whole I think it was a couple of years ago with Professor Talley, we were up here talking about match and whether that was, I think it was right before the Supreme Court decision came out, so we were debating which way it's going to go out. It was going to come out, and of course Professor Talley was right and I was wrong. But what we were seeing then, the so-called MFW creep, right? This idea that if you were to enter into something as simple as a commercial agreement, right, with a controller, the right way to do it was to go to get a majority of the minority shares plus setting up a special committee for something like that. I think was a little bit troubling, not because that's what the law required you to do, but because there was this increasing perception in the market that that's what you were supposed to be doing, right? So it's in that context, I think, and some of the things. There's definitely the feeling that Delaware was losing the franchise because of decisions dealing with some controlled companies, and all this results in SB 21 this year. Is it a huge departure? I don't believe it is. I'm putting aside the 220 changes. I'm more focused on the safe harbor provision. I can tell you, and you don't have to take my word for it, but corporate lawyers are not going to start misbehaving and telling clients to do, or boards or special committees to do the wrong thing because, hey, now we have this statute and it's license to kill here. That's not. I don't believe that's going to happen. I've not seen it happen so far. As it relates to, I guess, 144C, the section dealing with take privates, I've not seen much of an effect right now. I was talking to Ed earlier, and I had a survey done a few days ago by, it was a first-year associate, so it's definitely not up to standards of, the academic community here. But, since the amendment was passed earlier this year, there's been 6 sort of controller take privates, talking about public companies above certain market threshold. There have been 6. 3 of them used a safe harbor, 3 of them did not. 50-50, whether you do it or not. To me, at the end of the day, what matters in whether you set up a majority or whether you include a majority of the minority is not what the safe harbor itself, but whether you have a controller that owns 80% of the stock or 51% of the stock, right? If it's closer to 80% or more, then it's a business question for the buyer whether they want to put the transaction at risk, right, by having a potential ARB or activist go out and buy a big chunk of stock and effectively have a veto right over the deal. It's not so much what the statute says. I think, again, and I'll end here, I think it's more a reaction. The SB 21 was a reaction of the time. I think it was the wrong direction. In the right direction, I don't think it's going to unleash any massive disruption to the way we do deals. So I guess I'm a little bit less cynical than others as to the statute.
Jump in and kind of just on one point. In practice, I have seen, if anything, for purposes of setting up committees, maybe more of a focus. And I know, and you had pointed out, the provisions that basically say if you meet stock exchange independence, you're presumed a heightened presumption of being a disinterested director, but that is just a presumption. And there's now actually, probably in what I'm seeing, more focus, because there's more focus on the front end when a committee's established, and then the committee will hire its own counsel and they'll do another cut at, are these people truly independent? Do we need to think about whether one or more of these folks should not be here? So they're actually, from like a practice standpoint, I would say, if anything, there's been maybe increasing focus on vetting who goes on a committee.
So before SB 21, all directors were presumed to be independent.
So saith you.
So saith Delaware law, right? There was a presumption that all directors were independent.
That is true.
So Anne, did you want to say something?
Well, I just a couple things. So one of the things about match means that every single minor controller commercial disagreement. I'm not disagreeing with how you say boards perceived it or whatever, but that was always just seemed to me such a misleading thing. Anyone who wants to bring a claim has to bring it derivatively. You're subject to the demand requirement. It is single cleansing for just about any other thing, like director cleansing as a practical matter because of the demand requirement for most commercial ordinary relationships with the controller. I never really bought that was that burdensome as a practical matter. But beyond that, see, here's the thing. am not, I don't even necessarily disagree that boards are taking this very seriously, and that, you know, boards are taking, you know, they're not going nuts, and that no council is telling them, well, that's it, you can do whatever you want because no one can sue you. What I think this statute absolutely those signals is they don't see much value to shareholder litigation in enforcing those standards. That what I'm hearing is, but boards just kind of do what they're supposed to do, and their lawyers kind of counsel them to do what they're supposed to do, and they know they need a shareholder vote at the end of the day, and they get yelled at by shareholders who have big stakes if they don't. And this is saying that we don't need shareholder litigation to be part of that picture. Now, maybe that's right. Maybe over time we will see that to be less right. I remember that after Corwin, I mean, it was a Delaware judge who wrote, and I forget which one it was, honestly, but they wrote it down. It was published and everything, about how after Corwin, boards had a sense of, well, no one can sue us, so maybe we can play a little fast and loose at the edges. And I'm just not sure that this will not erode as the threat of litigation diminishes, and this is where, as you know, the changes to books and records comes in, because you can still rebut independence, but it's going to be a lot harder if you don't have access to internal information.
Okay, and I want to, before we get to the changes of books and records, which I do want to touch on, I want to go back to John Mark for a second, and just, you know, these changes came about pursuant to a very different process than they typically do, right? They didn't originate with the council. They instead originated with a few lawyers and then came to the council, and it happened, you know, sort of off cycle, more quickly than typically happens. All my students from corporations will remember, because we were all very traumatized when all of a sudden a whole semester of teaching had gone out the window in February of 2025. So, you know, can you talk to me a little bit about what was the thinking inside the room for doing this, you know, so quickly? Was it a response to some of these pressures that Eduardo was talking about, the grumbling, and you are also advising companies? You're probably hearing a lot of these same complaints. How much of that was coloring? How much was the fear of exit to other places was coloring the decision to move in this way and the substance of what you were doing?
So, just a little bit of background. So I think there's probably some amount of misinformation about how all this came together. I think in your article you talk about, you know, this nor'easter descends upon Rodney Square in Wilmington, and then this, you know, phalanx of Richards, Layton, and Finger lawyers meets in a conference room on Valentine's Day weekend.
We already sold the movie rights, by the way. So.
And then we're sharing conversation hearts, exculpate me. And that all sounds pretty cool. And you know, this powerful, all these people kind of, but unfortunately, the reality is a lot less glamorous. There was not a group of us in a conference. It was just me. I was in the office, but and by the time Valentine's Day weekend rolled around, the draft was largely finished, and it was really just, you know, me kind of putting in some changes, sending it off to, you know, Leo Strine, Larry Hammermesh, and Bill Chandler, and then getting some feedback and turning drafts almost like their associate, or clerk. But how did this how did this come about? We'd been hearing a lot. I mean, frankly, since the Tesla decision, Delaware has been in the headlines. And there have been questions. I mean, look, when somebody who has 100 million followers or however many million followers says never incorporate your company in Delaware, that's going to get some traction, right? And a powerful person who has a lot of other powerful friends who, you know, then would kind of turn on, you know, Delaware. So we were looking at this. You know, I was at, this is at the end of January, I was out at an M&A conference in California. That was when Dropbox had announced that they were leaving. Meta, there was an article that was leaked to the Wall Street Journal saying Meta was considering leaving. And there were just other, and this was all in the background of, we all knew that a lot of people were dissatisfied. And whether some of that's perception or not, it doesn't really matter. There was a sense in the broader market that there were some issues. And what were those issues? Those issues were that books and records demands had been perceived as getting a little out of control. I think folks didn't like the idea that, you know, every single books and records demand that came in, you know, looked like, you know, a wish list of discovery in a plenary proceeding. And now you've got to go around and collect. And theoretically have 5 business days to do this, but collect everybody's devices, and that was viewed as getting out of control, way too expensive, very onerous, very burdensome. But then also, look, the match decision, I think it did. A lot of people, I think, were hoping that was going to come out a different way, and it didn't. It came out the way that, look, there were different, there were different folks had different ideas as to where that was going to come out, and it came out where it did, and it didn't resonate well with a lot of folks. But there was also just a sense that the litigation environment generally in Delaware had gotten too extreme, where it seemed like most deals were getting some type of suit, at least certainly getting books and records demand, but then ultimately resulting in some complaint getting filed. And the thought was, look, there are, the first step on the road to recovery is to recognize you have a problem. And so, I heard from, we'd also had, when the new governor came in early to mid-January, he was very focused on, burnishing the Delaware brand and promoting the Delaware franchise. We do think we do corporate law better. We do think we have the best courts, and I believe that wholeheartedly. So we'd already had an ad hoc group. He called me and said, hey, seeing a lot of this news, what do you think? I said, look, here are some issues that I'm hearing in my practice, but you should talk to a lot of other folks. Certainly don't talk to as many people as you can on every part of the spectrum. So not just corporate lawyers, not just plaintiffs' lawyers, but everybody. CII, talk to everybody. And I think he and his team did go out and talk to a lot of folks, and there were some through lines that came out of those discussions. One was that I think a lot of folks were saying the same thing, which is we're having a more difficult time figuring out whether directors are independent, and that is just, look, you could agree or disagree, but on the front end, folks were having that issue, or at least there was a perception that was going to be a real issue. And so we kind of heard some of these things that were being said, and we took the through lines, and they matched up pretty nicely with an article that Chief Justice Strine and Larry had put together, optimizing Delaware's corporate law for the future, whatever. But and so we tried to, this is late January, early February, we started mapping out, the structure of the, what became SB 21, and over a period of a few weeks, we came up with a, work product that we thought was worth putting out there. And then the idea from the get-go was that it would, get introduced, and then go to the, Council of the Corporation Law section, have them vet it, either nix it or, revise it. And they did revise it. That was kind of how things unfolded.
So Ed, in your piece, your recent piece with Marcel Gahan, you talk a little bit about why this came to be at a higher level. What forces brought this moment in Delaware about. Do you want to tell us a little bit about what was the catalyst?
Let me start with what I take John Mark as saying about the initiation of the process, which, filling in, and I think it's accurate, is there was a sense in Silicon Valley, primarily, I think it was maybe elsewhere as well, but there was a concentrated sense among controlled companies in Silicon Valley, Dropbox, Meta, both controlled companies through dual-class capital structures, that Delaware was not going in the direction that they were comfortable with. And there was a sense, and I heard this from lawyers, that they were getting a lot of calls from Silicon Valley clients talking about maybe they should think about moving to Texas or moving to Nevada. This was something that was clearly amplified and maybe initiated by Elon Musk's rage tweets post Tornado against Musk. But that it was a serious sense in Delaware that the dual class controlled companies might leave. And there was also a view that for Delaware legal practice and for Delaware corporate law, that would be a bad thing. Now, what's so striking to me about that as the initiating cause that led, as John Mark described it, to depart from the standard lawmaking approach in Delaware, which starts in the Corporation Law Council, responding to comments and criticisms of the law that the bar may generally have, but that the Corporation Law Council has historically been where lawmaking initiates, and then historically a very deliberative, extensive process is pursued. That was not the system that was used. Now, what troubled me and what we discuss in the paper that you mentioned, the first thing that troubled me is, and this goes back to what a lot of us have spent, I don't know, the last 20 years thinking about is how do you feel about dual class capital structures? Jeff wrote a famous article much longer about midstream recapitalizations and the problems that midstream recapitalizations have. And midstream recapitalizations never were a big thing after Jeff's article and after change. But the core question of how you feel about dual class capital structures where an equity holder who has 10% of the equity can nonetheless have more than 50% of the votes. Now, for the longest time, I was in the camp that was not concerned with that because I thought, you know, they go public that way, shareholders have a choice whether they invest in or not. And there's a marvelous article that Kobe Castiel and Lucian Bebchuk wrote about the perils of small minority controllers, in which they argued that small minority controllers, a 10% equity holder with a majority of the votes, has an exaggerated incentive to take side payments, private benefits control, as compared to a traditional controller. So Bill Gates at Microsoft had 50% plus or minus of the equity. He never took more than $675,000 a year as CEO because, of course, he got half of any increase in value of Microsoft, so his interests, though not perfectly aligned, were largely aligned. But if you only have 10%, there's a much greater wedge between your interests and the interests of the other shareholders. Now, when I first read that, I was, again, unperturbed because I said to myself, Delaware is at its best in controlling private benefits of control. Delaware is at its best with the duty of loyalty. That's what Delaware does, is it regulates and oversees breaches of the duty of loyalty, conflict of interest transactions. And then I realized as I was watching this unfold that Kobe and Lucian had stopped too soon in their analysis. Because not only do dual class controllers have a strong incentive to take private benefits of control, they equally have a strong incentive to dilute the regulation of those private benefits of control. And what we saw unfolding was this expression of the dissatisfaction of the small minority controllers with being regulated by these smart Delaware judges who were looking closely at conflict of interest transactions involving controlling shareholders. But what worried me as we worked through, as I watched this, what worried me even more is the fact that Delaware would respond, as it did, to these demands from the small minority controllers. Because it turns out, and this is the lesson, that one of the lessons I took away from this, is that a small minority controller can, with simple approval of the board of directors, who of course is serving at the pleasure of the small minority controller, with an approval of the board of directors, the small minority controller can leave Delaware. Because they can unilaterally approve the transaction by which you leave Delaware. So that it means that a small minority controller with these very, very problematic incentives can credibly threaten to leave Delaware. And what we saw with SB 21 is that Delaware will respond to those threats. Right? It was those threats that got everybody's attention. And at the end of the day, with SB 21, because I don't think it changed the law in a dramatic sense, I don't think it will provide the reassurance to the small minority controllers that Delaware is a safe place to be a controlling shareholder. So I expect them, having proved the concept that they can credibly threaten Delaware and succeed, that once they realize how little SB 21 does, they'll be back asking for more. And it's this dynamic that has turned me against dual-class capital structures, because it turns out that they're not as harmless as I once thought.
So Anne, I know you want to jump in here, and then I want to take Eduardo's temperature on whether this narrative is fitting with what you've seen behind the scenes. Yeah.
So I just have a couple points. So the first, one of the things that ironically, since I read the controller things differently from you, let's assume for a moment that I've got the right reading in there. What this statute actually does is discourage the use of dual-class companies. It actually encourages the use of contractual control, because that way you can avoid being regulated as a controller. So I'm really looking forward to empirical people who are not me studying whether we see actually more use of contracts in place of dual-class companies. And the reason that's interesting is not just because, if I'm right, then that means they escape sort of the controller box for the purposes of fiduciary review. The thing about contracts is they're personal, they can't be inherited. Now, a lot of dual-class companies, they kind of sunset anyway, one way or another. But contractual control pretty much ends when the person on the other end of the contract dies. So that's actually like a new, that may, in fact, in some ways push this in a sort of interesting new direction that is, in some ways, I think, a good thing, because it's less possible to have dynastic control. But the other thing, and it's not that I disagree with your story, I have a sort of complication of it, which to me is about like how this came back, because I agree, this is a lot of a Silicon Valley-ish thing, but I think a lot of it is coming from this space of private companies, like companies were able to stay private for a really long time, and in that context, while they were being private, they developed control structures that they were perfectly happy with, that had founder control or controlled by a founder and like a couple of VCs. They were controlled companies. They did incredibly well from a profit standpoint. They had absolutely no trouble working with their friends over and over and over again. And then when they went public, they kind of resented somebody saying that, like, you can't do business the way you've been doing business all the time. They developed a real ethos about how you should run a company, and it included essentially singular control. A small group of insiders, and who were on the board, and they went public that way. And they kind of assumed that they should be able to continue to run their companies as public companies exactly as they'd run them as private companies very successfully. And I think that that's where some of this anger came from.
So yeah, Eduardo, what do you think? Is this a controlled company exerting pressure on controllers, tech broke controllers, dual class, taking over Delaware corporate law, or what do you think?
Yeah, listen, it's hard to argue with sort of its perspective that it was, some of the people that control these companies that exerted, very, very public pressure, sometimes in ways that certainly I wouldn't, would have rather not seen out there. But I do think that simply amplified an issue that was relevant not only for controlled companies, like dual-class stock companies, but an issue that was impacting many companies that don't fall within that specific profile, right? I'm going back to the MFW and the application of MFW, right? There were a number of situations I saw where you had, a company maybe that had gone public, so they still might have a large founder in the stock, but by no means, there was not a, 50% plus controller, but there were still concerns that, given the direction that Delaware law was heading, that groups within the board or amongst the founders, like plural, I'm not talking about a group, but number of people some of whom could eventually roll their stock, for example, in a transaction. And the question at the outset was, well, the company's putting itself up for sale, right? The founder sincerely doesn't know at this point what they're going to do with their shares. They might roll, they might not roll, they might be sellers like everyone else. So at the outset of the deal, how should we be planning for this, right? Because certainly there's going to be a lawsuit at the end of the day if these people decide to take stock, where we're going to be told that, you know, we should have done MFW, and of course we failed to follow the ab initio, you know, prong of the analysis, and of course there's no way that we could have done that back then when we didn't have an actual buyer. So there were a lot of issues like that were really becoming, you know, problematic for transaction planning purposes. That does not apply only to the dual class, you know, companies. Now, would this have happened but for the dual class companies raising the type of, you know, public attention that they brought to the issue? Probably not.
Yeah,
So I'll just,
And then
sorry,
John.
just really quickly. No, but I think dual class put a lot of the pressure. I do think there were other things, like they were worried about startups, like where the startups would start, which, I mean, it's controlled in the sense that it's a startup and they're picking where to go, but it's not the same dual class problem. I think they were worried about a lot of where the startups were going to go. And I think also books and records was a big concern, and I think Caremark was a big concern. I know, and Walmart's not dual class, but Walmart was one of the controlled companies that was threatening to leave, and Walmart's concern is being sued for opioid stuff. So, I mean, I think that books and records, but you cannot publicly write a law that says it's totally fine for directors to break the law. So what you write is a law that says shareholders can't get access to any information they need to prove that directors broke the law, and that's pretty much the next best thing.
John Mark.
So I think it's too reductionist to say it was just dual class. I think there was a much broader group, and I think Ann makes a good point that, yeah, look, we do care about getting startups to form in Delaware, where we do like the fact that the NVCA docs are based on, you know, a Delaware charter and Delaware documents. And, you know, at the time, you know, before, there were a lot of law firms that were putting out, you know, matrices showing Delaware versus Texas versus Nevada. And there was just a lot of chatter in the market about, you know, where to incorporate. So this was not just, you know, undue pressure. And look, for what it's worth, a lot of people in Delaware, and we work with everybody across the country. I mean, this was not just like a couple of folks coming in and saying, hey, we're dual class, you know, big bad tech bros, do what we say. We knew there was a broader problem. There were also I think there was a sense, whether it was right or wrong, there was a sense that things were getting less certain in terms of who's a controller, when are you a controller, transaction-specific control, who's independent, who's not independent. If I'm on a yacht with somebody and we're at, you know, we get a picture taken, am I now not independent? Those were the kinds of things, right or wrong, whether they were apocryphal or not, those were the kinds of things that people were saying. And we wanted to kind of signal, like, look, we're going to try to put some bright line, and bright line rules will have the effect that bright line rules have. Sometimes, you know, some things are going to squeak by. That's just how they work.
Can I just make one?
Yes,
So,
sure.
When an industry gets started, when a process gets started, people get invested in it, and they want it. The direction they're going, they want to succeed. And so, as I read it, and I never knew, I could never tell how much of this was driven by dual class controllers, and how much was driven by some folks who had written a really interesting article about how Delaware law should change, catching a ride on the pressure from Elon Musk and the dual class controllers to implement the reforms to Delaware law that they had argued for in their Business Lawyer article. And I'm sure it was a bit of both. The result of that was, I think, a rather implausible claim about the likelihood of firms leaving Delaware. Here we are sitting in the Joe Jamail auditorium. And many of us remember Joe Jamail as the Texas lawyer, number one, who's banned from Delaware, and number two, who litigated the most famous corporate law case in Texas, namely Texaco versus Pennzoil, where a jury came back with, I think, a $10 billion verdict. A verdict that soured everybody on incorporating in Delaware for at least 30 years, in Texas for at least 30 years. The idea that Texas, which still has a right to a jury trial in the state constitution, that in its new business court, 50% of the cases opt for the jury trial. The idea that Texas is somehow a credible competitor for Delaware is absurd. But it was a useful boogeyman to point to either pursue the interests of the dual class controllers or the law reform interests of the authors of the article, or a combination of both.
Yeah, so I agree with that. I think that part of the perception here, at least from those of us who are not talking to anyone and just watching it from the outside, very much felt like, I can believe there are threats, I can believe there are credible threats. I do not believe that every single bit of the statute needed to go quite as far as it did in order to neutralize those threats. Like, I think reforms to books and records were inevitable at some point. Define a controller more clearly was inevitable at some point. But it wasn't obvious to me that it needed to go, like, every single bit of this, like, kept getting tweaked to be more and more insulating boards. Like, there was at one point a proposal that at least the dual cleansing mechanism in controlled companies not just go privates, but for anything that requires a shareholder vote. That seemed like a fairly neutral, like, reasonable place to draw the line, but no, that was rejected. And I'm reminded—
That was the proposal of the appellants in Match.
Yeah, so right, but it was actually proposed as a change to the law, and it was rejected. And here's the thing, we're also living in the shadow of SB 313, which is impossible not to watch this unfold without thinking about SB 313. And one of the things that I found so interesting is that after SB 313 passed, there's that article by I don't know how to pronounce their last name, Shobi, is it Shobi? And Clayton, the three BYU-ish Utah people, they wrote this article where they studied shareholder agreements. And remember, SB 313 was pitched as, this is the market practice amendments, we want to conform the law to market practice. And they did a study of shareholder agreements, and they found that none of them go as far as Mullis. Mullis was, like, wildly off the charts different from any other normal shareholder agreement. SB 313 didn't need to go nearly that far. To me, SB 313 reads like the No Client Left Behind Act. It's as though lawyers went and they said, but my client has this one idiosyncratic provision, so I need to change it again. Oh, wait, no, but don't forget my client. That's how it reads. So this is why you get the feeling that it's not that some version of SB 21 wasn't necessary, but, like, that it went much farther than you really needed to actually conform to what was being demanded. And one more thing about Texas is I could go talk about Texas forever, but one particular thing is this. There was this recent over-dispute between Pfizer, Metsera, and Novo Nordisk. And I read the complaint as soon as Pfizer filed it. And the only thing I could think reading this complaint, and we all know that some of the lawyers are very unhappy with VC CERN's decision there, but you read the complaint, and the only thing I was thinking reading that complaint was, there is no way this could be filed in any jurisdiction other than Delaware. Like, the idea that these incredibly complex contractual terms would be decided by, I don't care how sophisticated the business judges are, they aren't familiar with merger agreements. And just the idea that any other court than Delaware could possibly have handled that dispute, or anyone would have been comfortable handling that dispute. I mean, Delaware was just not that much under threat, I think. Threat, certainly, but this far?
Okay, I'm gonna pivot now to get into some questions that I want to ask John Mark about, some of the things that Anne and Ed and Eduardo have put on the table already. So, one is these standard pivoting to New York Stock Exchange, looking to New York Stock Exchange listing standards as a standard for independence. What was the thinking there? I mean, because, as Anne rightly pointed out, these things have nothing to do with controlled companies. The inquiry for independence under New York Stock Exchange standards is whether you're independent from, an executive is independent from their company. So what was the thinking of using it there? I'd just love to hear from you.
So the thinking there was that one of the messages that came across loud and clear from all of these companies, not just the dual class ones, was that they were having a difficult time determining at the outset who is an independent director. And so part of the thinking was, look, let's use a bright line test, but that bright line test, to Anne's point, is not going to be perfect. It's not going to fit every situation. And so the idea was, let's try to come up with a middle ground where it will be deemed to work for disinterested director status, but it will only be a presumption, but it's got to be a pretty heightened presumption.
What's the difference between a presumption and a heightened presumption?
I think the only way you can think of it is you better have something that's goddamn good to get to, it's got to be good, right? It's not just they once went on a bachelor party weekend or something like that. It's got to be good. That's the idea.
Castrated calves together.
Okay.
That's my favorite example.
Sorry, Anne, what was that?
The castrated calves case. I would never get past it. The one where they were not independent of the controller because they went on vacations where they castrated calves. Never mind. It's a real case. I don't know what to tell you.
Steaks too. Not just the calves. They also grilled steaks together.
Okay, so other drafting design questions for you, John Mark. So we have two people in the audience here today, two organizers of this event, Jeff Gordon and Eric Talley, who came out swinging in favor of an opt-out or opt-in amendment. Was that considered? And if not, why make this apply as a matter of default to every single corporation?
So look, a couple of things. Number one, to have the statute be an opt-in, are you basically saying, here are the companies that, and if you do it through a charter amendment, here are the companies that are going to opt in, now go sue all the other companies. And then you have this disjunctive law where we have, this set of rules applies to these folks, this set of, and we just thought, look, have the law apply across the board. Don't create, a class of, chum in the water corporations. Have it apply universally. And look, if you're thinking about whether to, opt into the statute, doesn't that just trigger or should we opt into Nevada?
I think that they didn't want the opt-in partially because they didn't want to slow the train, and partially because nobody wants to stand up and say, let me do conflict transaction freely. That's who the chum would have been, not the ones who don't adopt it, the ones who do.
Try to get that past ISS and Glass Lewis.
So Eduardo,
as a practical matter, I think it would have been very difficult. To the extent that you were trying to amend the statute to, release some of the tension that some stakeholders were under, I don't think it would have gone. I don't think it would have done much, if anything.
So you wouldn't have been in favor of an opt-out amendment, opt-out in? No.
To get a
well, you can opt out.
Yeah,
You can opt out.
This was going to be my next question.
Opt out.
Can you opt out, and if so, how? And this kind of also relates to the discussion about shareholder agreements. When you were drafting this thing, did you think about the interaction with SB 313 and 12217 for everybody who's here from my class? Could you use a stockholder agreement to opt out? What are the ways that you can opt out?
So, look, I haven't thought about exactly how I would implement an opt-out because no one's asked me that question yet. No one is going to pay me to have them opt out of 144, is my guess. Could happen, but it's very unlikely. How could you? Look, you could amend your bylaws to require the controller to be on every committee. There's your opt-out.
And
no, I'm not going to, I doubt anyone's going to want to opt out completely. I can imagine a world of shareholder agreements and even, I find it very hard to believe that Delaware would not enforce a charter provision that said something like we're setting our own higher bar for conflict transactions. But beyond that, it's relatively, they do it in merger agreements. You could have things like the controller promises not to assert certain defenses for certain kinds of transactions, that kind of thing.
And director qualifications are clearly a proper subject for tailoring.
Okay, great. How about one more topic before we open it up to questions? Anne's brought up 220 a few times, and I know you've said a lot of critical things in your, commentary to the press about 220 in particular. And this is something that keeps coming up in my conversations with people, where they say the big change in the statute and the harmful change, in their opinion, is the limit on the scope of what you can get from 220 actions. And so, Anne, maybe you can just kick us off by telling us, what is it you're concerned about? I mean, we heard already that there was this concern on the other side. There was these, exhaustive requests for information at the, the motion to dismiss stage. What bothers you about this? What's the
I
risk?
don't know. I think that let me put it this way. I don't have an ideal perspective on this. It's more like what I think the effects will be. I think that one thing is that so the books and records, which doesn't completely deny access to informal materials, but heightened, and it's got to be specific, and it's very unclear how that's going to be exactly administered, because how specific do you need to identify the document that you haven't seen, that you don't know if it exists? I don't know what courts are going to do with it. That said, my concerns are twofold. First of all, I think this is basically a way of kneecapping Caremark claims. I think that a lot of the 220 requests were coming out of Caremark claims that were coming post-Marchand. And so how one feels about Caremark claims, I personally have to be very conflicted on the subject. So, but I think this is a way of trying to get at Caremark claims. And but the other thing is that given the sort of heightened independency stuff, and did they act with good faith when they created the committee? Did they act with good faith and not gross negligence when they approved it? I think that's very hard to be able to combat for pleading purposes if you don't have, if you just have formal board minutes. But I mean, one thing I will say finally on this is that, for all of my doom and glooming of, how easy it is to bring claims, I do have to note that somehow Chancellor McCormick managed to find that the plaintiffs pled a claim in Activision based solely on bad faith and without any conflicts just recently, and that got passed a motion to dismiss. So maybe I am being too overstating what the effects will be, because I'm kind of shocked by that Activision result. But that was basically a way of dealing with allowing a merger claim to proceed without any conflict showing at all. So yeah.
Yeah. So Ed and John Mark, I wonder if you could speak to this. Like, do you think? And I know there is a safety valve within this, right? There you can get additional documents even within 220 if you show certain things. You think it's clear and compelling evidence. John Mark, was this intended to be a big gap that people could use to get documents as needed, or that the Chancery Court could allow to expand the scope?
No, I mean, it was not intended to be a giant loophole. It was intended. I mean, look. First of all, I'll say in defense of where we came down on 220, it's still more expansive than the books and records rights in just about any other jurisdiction, right? It was the template does not, it follows in some respects the Model Act, but then goes beyond. Specifically allows 122.18 agreements. So yes, we did have 122.18 very much in mind. But look, I think in circumstances where, and people, you'll be able to figure out which circumstances they are. And I think our courts are actually very good at discerning when things are severely awry. I think they probably will allow folks to go further where the facts are pointing towards some kind of, either fraud or severe egregious wrongdoing.
All right. Any questions from the audience? Jeff, you want to stand up behind the mic?
Yeah. So I think the influence of Elon Musk on this, the dynamics here, if you're telling the history of it, should not be understated. Because what he showed is if you have a sufficient control position, you can get a lot. And so, the Solar City thing that he was able to get, and the compensation that he was able to grasp, and of course the irony is now in Texas, under the new comp agreement, he wants 25%, because 25% is control and 21% is not. So, but I think and this really channels Ed's point, which I thoroughly agree with, the proliferation of dual-class common stock among a relatively young group of founders working with, an organized community of VCs has heightened the sense of entitlement. And what Elon Musk shows is from that stems the right to grasp the opportunities that you want when you want it, to reallocate the parts of the firm that you control to your other related activities. And the idea that the courts are going to get in the middle of that to disrupt that, I think was just seen as, objectionable. And so, this statute deals with a certain panic about that. But in the end, I don't think it's going to be successful. And I think, I was talking to the lawyer who was the lawyer for the Twitter board, who has a lot of clients, Silicon Valley. They want to go to Nevada, and the question is, why shouldn't we go to Nevada? And he's trying to tell them, there will be complex matters in which you'll really need good judges to figure this all out. But, basically, I think the idea that courts is in some way limiting the flexibility that this newly empowered group of dual-class common shareholders had is going to be the big challenge. And so I think in the end, I'm toying with this idea anyway. Bill Carey was right that there will be a race to the bottom for a significant group of very important U.S. firms, and that some national solution will be required. And you don't have to go full Elizabeth Warren to sort of think the terms of what the national solution will be, but it does seem to me that the grasping really has no limits, and the history of the Delaware statute that you've described is just, I think it's an episode in that, and I think we'll be struggling with that for some time to come. And I guess the question is, what do you think?
All right, anybody want to respond?
Look, I actually don't think Delaware is in a race to the bottom. I don't think this was an effort to. I actually do think this was an effort to try to reach some type of balance that a lot of folks who put a lot of thought into this thought was the right approach. I don't think that Delaware is going to. I don't think Delaware is going to race to adopt some of the innovations that we're seeing in Nevada and Texas. I think some of these, the federal question. I'm not going to. I don't know that I can comment on, whether the federal government would displace the field, but that doesn't seem like a perfect solution to me for anyone.
I mean, the real testing point, I think, is going to be really on the Caremark-Massey line, right? When Delaware tries to hold directors accountable for violation of law. And if you can move out of Delaware and avoid that, I think that'll be as much of an engine as anything else, really. And what's kind of relevant here is what Laster said at the end of McRitchie, when he said that Delaware is a small state. It has no stickiness, as it were. It's not California, where you have to do business in California, really, in an economic sense. And ironically, Delaware is a hostage. The revenue that it gets it makes it a sort of vulnerable to hold up in precisely the way that we saw, the way that the immediate recourse to the revenue threat to Delaware was kind of embarrassing. We're for sale, and we can't afford to be principled or tough or whatever you want to say, because then, the tax base is gone. And when you reveal how exposed you are to threats of that type, I think, the pressure will next come, I think, on the the Caremark-Massey line. But there will be stuff like that I think it will be very hard for Delaware to sustain its high quality, quote unquote, standards. And, I think that'll be a thing we'll be dealing with over the next period.
Yeah. Well, I mean, look, I'll dispute the premise that it's purely revenue. I think a lot of folks actually thought these were needed reforms, that this is the right approach for just generally for corporations to have clear guidelines. So I think that is, maybe I'll dispute the premise a bit, but I hear you. I mean, it's people have been saying that for years.
I mean,
Ed, you can jump in.
a couple of responses. One is, as we watched the new Musk compensation in Texas, one of the things that stands out is that one of Texas's great comparative advantages is that you can adopt a bylaw that requires 3% of the shares to bring a derivative suit. That's $30 billion in shares in Tesla, which essentially provides what many companies would like, which is insulation from derivative suits, which gives you insulation from the Caremark claims as well. The TripAdvisor opinion, which I think was a correct opinion in the sense that Delaware can't be perceived as forcing companies to stay. The TripAdvisor opinion provides an incentive for controlled companies to leave a year or so in advance of trying to do related party transactions. It creates that incentive because as long as you leave on a clear day, it's business judgment rule. If you leave when you're in the process of doing a related party transaction, it may not be. And so you create these incentives. I think your reference to Bill Carey is right. I mean, the issues that Bill Carey raised 50 years ago, 60 years ago, are issues that come up every single time there is a corporate scandal. The pygmy meme that he coined there is a repeated one. And what's, I think, most troubling in our current situation is the politics around it have changed. So Delaware is a totally blue state. Historically, the presence of a Delaware senator on the Senate Judiciary Committee was a very effective block against any attempts to nationalize corporate law. But we're in a different world in which, and one of the things I worry about, for instance, the speech that was given at the Weinberg conference, what was essentially a rule of law speech at the end. If corporate law politics maps culture war politics, and the contest between Delaware and Texas for charters becomes a contest between a blue state and a red state, that's a very bad place for Delaware to be, because then the political vulnerability at the national level becomes an order of magnitude more severe.
And you want to?
Yeah. Well, I'm not sure I'll see. I don't expect to see a big pullback from Caremark because I think they've done that with the books and records. I mean, I think that's what that was a proxy for. But yeah, I think that was pretty much my main thing. I expect that we're going to see more contractual agreements for very specific kinds of protections. And one of the interesting things, though, is that companies can, like, if what companies like is Delaware courts for the purpose of deciding contractual disputes, but not so much for the purpose of deciding fiduciary disputes, because I'm sorry, I know that you've said several times our courts figure out, they're good at sensing when something's awry, and this whole statute says that you don't, in fact, think that courts are very good at sensing when something's awry. This entire statute says Delaware's been getting it wrong all this time, but where it seems everyone still trusts the Delaware courts is complex contractual disputes. Well, companies can have that very easily by incorporating in Nevada and using a Delaware choice of forum clause for just about everything else. So that's kind of the future that I think is somewhat being encouraged here.
I would say just one further point. I think the next issue out of Silicon Valley is going to be the ability to have arbitration.
Yeah.
But
arbitration. But not for earn-out stuff.
I think there's going to be now I would predict pressure from Silicon Valley to amend Section 115 of the Delaware General Corporation Law to allow firms to opt into arbitration of intercorporate disputes.
They could also do it by shareholder agreement.
Yeah, so I don't know that that's right.
We'll find out.
Because arbitration is a mess first and foremost. I think a lot of people think it's going to be cheaper,
Silicon
quicker.
Valley likes it. They were opposed to the amendment when it was taken away.
Yeah.
Okay, we have 1 minute to go,
Okay.
and Professor Fish has been waiting so patiently. So let's
Not patient at all. No, I was just hoping that John Mark could follow up a little bit on Anne's point about director independence, because you said several times that the goal was to have sort of more bright line standards, and I guess I'm a little bit confused, because on the one hand, there's the New York Stock Exchange presumption, and maybe it's a stronger presumption, but there's also this idea of material interest and material relationship, and is that now supposed to be an economic relationship, which the definitions don't say, or are these old social and professional relationships that sort of were built into the Delaware common law definition of director independence, do they still exist, and is that the way you get over the presumption?
I think they still exist. And look, those definitions were largely, they appear in other statutes. And those other statutes, including the Model Act, were based on a lot of Delaware case law. So I think there's a kind of a circle there.
Well, then what exactly does the stock exchange presumption get you if you're still going to be looking at material relationship and material
It
interest?
gives you a heightened presumption.
All right, with that, let's give everybody a round of applause.